Number 3. Locke's problem. Locke starts his exposition on the origin of property by stating his fundamental thesis that God had given the earth to mankind in common. This is evident both from reason and revelation. Reason tells us that men, being once born, have a right to their preservation and consequently to such things as nature affords for their subsistence. Revelation is very clear to the effect that God, as King David says, and he might be supposed to understand the donation, has given the earth to the children of men. Locke further brushes aside Filmer's theory, criticized in the first treatise, that God gave the world to Adam and his heirs in succession to the exclusion of all the rest of his posterity. On that supposition, only a universal monarch could possess property, which Locke plainly finds absurd. But there was another, far more serious difficulty in the demonstration of origin of private property in things. If the earth had been given to men in common, how had it come to be that the community of goods, thus established, had been replaced by private property rights? Unless valid titles to private rights could be shown, the actual distribution of possessions would seem to rest on robbery, and justice would require the return to the community of goods. Locke had no intention of acceding to such claims. Grotius and Pufendorf had solved the difficulty by deriving the institution of private property from a compact through which the community of goods had been set aside. But there was another reason, too, for them to require an agreement as the foundation of the right of property. Dominium, as every other right, was a facultas moralis. It was a moral power in the owner over the minds of all other men to request them to abstain from the object and restore it if they had gained possession of it without the consent of the owner. No facultas moralis of one man over another could, however, be established without his consent. Locke rejects the compact theory of Grotius and Pufendorf. His argument is as follows. Like Pufendorf, Locke holds that men in the state of nature must be able to appropriate things necessary for their sustenance. Appropriation, which is a word frequently employed by Locke in his chapter on property, literally means making a thing proper to oneself, that is, making it one's own. Fruits, beasts, Locke says, being given for the use of men, there must of necessity be means to appropriate them some way or other before they can be of any use, or at all beneficial to any particular man. The idea is that a man cannot use a thing for his own benefit without injury to others, unless that thing, being by nature common to all, has first been made his own. God cannot have put man on earth under such conditions that he would be unable to support himself without breaking the law of nature, God's own will. Therefore, God must have instituted a means of appropriating the necessities of life. But appropriation cannot have presupposed general agreement. It would have been patently impossible to obtain the consent of all men on earth. Consequently, if such a consent as that was necessary, man had starved, notwithstanding the plenty God had given him. This is a retort to Pufendorf, who, without exception, had required general consent for appropriation in the state of nature. This compact theory cannot be upheld, Locke thinks. The real problem for Locke was, therefore, how to explain the origin of property without interposing a fictitious compact. The solution was facilitated for him because there was a significant difference between his concept of a right and that of Grotius and Pufendorf. Locke did not adopt the concept of facultas moralis. It was not a basis of his reasoning as it was for Grotius and Pufendorf. As far as I know, he never criticized this concept, but he ignored it. In the two treatises it is never mentioned or presupposed. This difference is highly important. It made it easier for Locke to explain the origin of private property without assuming a compact. Still, the problem remained. How could the original community of goods have been superseded by private rights to land and goods without an agreement to divide the common or to allow occupation? This must have been brought about without inflicting injury on anybody. Locke had to steer between Scylla of the compact theory of property and the Charybdis of robbery. Number 4. Appropriation. To solve the problem, Locke made use of the same idea of appropriation as Grotius employed, but on a far larger scale. Grotius allowed appropriation without the consent of others, only in the earliest stage of the world, and presumably for very limited purposes. It lost its importance with the introduction of dominium by way of convention. Locke, on the contrary, made appropriation the beginning and foundation of the right of property. An immediate continuation of his statement that there must be some means of appropriating the necessities of life, Locke explains by an example what appropriation implies. The fruit or venison, which nourishes the wild Indian, who knows no enclosure, and is still a tenant in common, must be his, and so his, i.e., a part of him, that another can no longer have any right to it before it can do him any good for the support of his life. Here we have a most unequivocal expression of the idea that the personality is extended to encompass physical objects. The deer that the Indian has killed is his in the sense that it is a part of himself. Locke is not encumbered by the notion that dominium is a moral faculty against all other men. He only maintains that the object is included within the sphere of the personality, or within the sum, as Grotius would have said, by being appropriated. But when the object has been included within that sphere, it will be an injury to the possessor to deprive him of it. For his own person is exclusively his own. Though the earth and all inferior creatures be common to all men, yet every man has a property in his own person. This nobody has any right to but himself. Therefore, an attack on that which belongs to the personality constitutes an injury, and the injured party is licensed to react with violence. Locke goes on to explain the concept of appropriation. His idea is that I infuse something of my personality into an object in spending some labor on it, for a man's labor is his own. The labor of his body and the work of his hands, we may say, are properly his. Whatsoever then he removes out of the state that nature hath provided, and left it in, he hath mixed his labor with, and joined to it something that is his own, and thereby makes it his property. It being by him removed from the common state nature placed it in, it hath by this labor something annexed to it, that excludes the common right of other men. For this labor being the unquestionable property of the laborer, no man but he can have a right to what that is once joined to, at least where there is enough, and as good left in common for others. The laborer has mixed his labor with the object. He has joined something to the object that is his own. By his labor, something has been annexed to the object. In this way, the object has been removed out of the state of nature. It contains something more than it does by nature alone, because the personality of the laborer has been infused into it. Therefore, it has become the property of that laborer. Since the labor is the unquestionable property of the laborer, no other man can have any right to that to which his labor has been joined. The exertion through which a thing is made my own need not necessarily be labor in the usual sense of the word. If the wild Indian kills a deer with his arrow, it becomes his. The case would be the same if he picks an acorn from the ground. This act makes the acorn his own. Labor is equal to action. The term corresponds to actio in the language of Grotius and Pufendorf. The example with the acorn is especially illuminating. Locke borrowed it from Pufendorf. But he makes use of the example against Pufendorf in order to show how things unquestionably can be made our own by apprehension without proceeding compact between all men. It is his chief example in this respect. Locke says, "He that is nourished by the acorns he picked up under an oak, or the apples gathered from the trees in the wood, has certainly appropriated them to himself. Nobody can deny but that the nourishment is his. I ask then, when did they begin to be his? When he digested, or when he eat, or when he boiled, or when he brought them home, or when he picked them up? And 'tis plain if the first gathering made them not his, nothing else could. That labor put a distinction between them and common. That added something to them more than nature, the common mother of all, had done, and so they became his private right." What Locke here calls labor is merely apprehension of an object. The acorn becomes the property of the collector when he picks it from the ground. This is the moment when something of his personality is infused into the acorn. Locke sums up his theory in the following expressive words: "From all which it is evident, that though the things of nature are given in common, yet man, by being master of himself, and the proprietor of his own person, and the actions or labor of it, had still in himself the great foundation of property." Man's power over his own person and actions, his potestas in se, in the language of Grotius and Pufendorf, is the great fountain of his right of property in things given by God in common to all. For by laying hold of a thing under certain circumstances, in the state of nature, he mixes something of himself with the object, removes it out of the state of nature, and makes it his own. He that so employed his pains about any of the spontaneous products of nature, as any way to alter them, by placing any of his labor on them, did thereby acquire a propriety in them.